Morning and welcome to the Court of Appeals. We have two cases on the 9 o'clock docket, People v. Lujan and People v. Lindsey. I see counsel are set up for Lujan. Does either of you have any questions concerning our procedures? For the benefit of our spectators, then, if any of you has a cell phone or similar device, would you please turn it off so the lawyers are not interrupted during argument? We're ready to proceed in People v. Lujan.
Good morning. May it please the court. My name is Adam Mueller. I'm appointed by the Office of Alternate Defense Counsel, and I represent Abel Lujan. As this court knows, my brief raises 4 issues, but since it's been 12 days since this court decided a public trial issue, I thought I'd start there. As a reminder to the court, the judge in this case, over objection, closed the courtroom to the public and excluded defense counsel, the defendant, and the prosecution when it answered a jury question in court. The court made no attempt to comply with the Waller factors that we are familiar with, and the only explanation the court gave for its decision was that you never bring the jury back out in front of the parties during deliberations. That, I think, is a plainly wrong articulation of the law. So I don't think there's much dispute about those facts. I don't think there is dispute about those facts.
Can you give us a couple of examples that show it's plainly wrong, to instruct what the judge said was plainly wrong? Why do you say that? I mean, what is your basis for saying that?
Well, I think there are tons of examples I've seen. I mean, the modified Allen instruction is given in open court. I'm not aware of, I personally have never seen a case where it's not given in open court. This obviously wasn't a modified Allen instruction, but that instruction is given in open court. When the judge asks, when the jury asks to review certain evidence, the judge, under DeBella, has discretion as how they do that, but oftentimes...
Under DeBella, did you say?
Yeah, reviews some, when the jury
Like
reviews
the
some evidence, under DeBella, some testimonial evidence, the judge will often bring the jury back out, give the jury an instruction about not placing too much weight on this particular piece of evidence, view it in the context of everything, and so on. So I think that, as a matter of law, to the extent the court said you never ever bring the jury back out in front of the parties during deliberations, that's just wrong. And that was the only explanation the court gave for its decision. Here, I think the case ultimately turns on whether the court's decision to do this and close the courtroom was trivial. That's the primary argument the Attorney General makes in response, is that this court should recognize a triviality exception to the public trial right, and that this was, in fact, trivial. Now, like this court decided 12 days ago in its decision in re the interest of GB, I don't think this court actually has to reach out and decide whether there's a triviality exception. Just as in that case, it did not have to reach out and decide whether there was some lesser standard for partial closures. And that's because this wasn't trivial under any definition. My position is quite simple. It can't be trivial when the court instructs the jury on a matter of law. Those instructions are given in open court at the conclusion of a case. They're transcribed, unless the transcription is waived, but we have, it's open to the public, the defendant is present, and it simply can't be trivial.
Counsel, the defense counsel at trial gave the trial court an alternative, which was to instruct the jury why the parties were not present. The trial court sort of agreed to do it, but then didn't do it. Had the court actually done that, given the instruction, would that have cured the error? And if so, why or why not?
It might have cured the right to be present error, which was similar to this court's decision or the division's decision. I believe it's in Payne, where the court gave a modified Allen instruction and in that case didn't offer to explain the absence of the defendant. And the Court of Appeals said we don't need to decide whether, had the trial judge told the jury the defendant is absent because defense counsel waived his presence or whatever, that would cure the error. So I'm willing to assume, for the sake of argument, that it would cure the right to be present error at issue here, but it wouldn't cure the public trial error. And the public trial error, although it certainly is about the defendant's rights, and the public trial right aims to protect the defendant's right to fair trial, it's about excluding the public from the trial, excluding the press, excluding spectators, and we had that as well. The court closed the courtroom here, the trial judge closed the courtroom and allowed only the bailiff and the court reporter and the jurors to be present. So,
If were we to decide the case in your favor on the public trial issue, what would be your position on whether we should reach the alternative ground of right to be present?
I don't think this court would have to reach it. I think it would be sufficient to say, because the public trial error is structural, this court wouldn't have to decide whether the right to be present error was harmless beyond a reasonable doubt, and there is a harm analysis there, where there isn't on the right to public trial. And I think it would be sufficient to decide on the public trial error, and it might not arise again on retrial. Presumably, the court would understand that it can't close the courtroom and would at least have to comply with the Waller factors, and that would raise the issue, presumably, in the court's mind, so this error wouldn't arise again. So I don't think the court would have to reach the right to be present error.
In terms of the triviality exception, is there a clear majority rule between jurisdictions that have considered it and adopted it versus jurisdictions that have considered it and rejected it? Or are there just too few cases for that to be a meaningful observation?
Your Honor, I don't know the answer. I haven't done a 50-state survey, although yesterday in preparation, I have not cited this. There was a Stanford Law Review article, a note I found in the Stanford Law Review. I think it was from 2016. I'm happy to file that as supplemental authority. The Attorney General obviously hasn't had a chance to review it, but it's a note that kind of does a survey in some sense of how courts have come down on this decision. And I think it's a few years old. It characterized a majority of courts that have addressed it as having recognized the triviality exception, and a minority of courts had not recognized the triviality exception. I looked at some of those cases, and I'm not entirely sure I agree with the note's framing of the issue, because some of those cases arise in the context of a partial closure versus complete closure and don't specifically address triviality. So I'm not sure that that's an accurate understanding of the state of the law. But there certainly is authority out there.
In terms of triviality, does it matter, or should it matter, that the lower court simply reread an instruction previously given, as opposed perhaps to creating a new instruction or, well, let's leave it at that. I mean, is that a component of triviality, and why or why not?
I don't think so, Your Honor. My position is any legal instruction to the jury has to comply with the right to public trial.
Well, what policies underlying that right are furthered if the judge is doing no more than reading to the jury something the judge previously gave, which I suppose could have, for that matter, could even have been done in writing?
A couple of responses to that, Your Honor. The first is, at the heart of the right to public trial is, transparency, is about the public seeing that justice is served and served fairly. So even if the judge is simply rereading an instruction, I think the judge's demeanor matters, for example. And in this case, there's a question about that. I have a footnote in my brief about, I think there's obvious frustration and tension and exasperation in this case between defense counsel and the judge. And I cited a lot of different pages of the transcript. I'm happy to give more cites. But pages 1399 to 1402 of the transcript are illuminating here. Defense counsel was making a lot of records, and it frustrated the judge. And the judge, the judge, as I said, was frustrated. I hesitate to characterize it much more, but I think jumping off the page, there was frustration. The defense counsel even made a record under the decision of Rapsky about bias and partiality. Now, I didn't raise that issue on appeal, but certainly there was an understanding between the parties that there was some tension there. With no one in the courtroom when the judge reread the instruction, we don't know what the judge's demeanor was. We don't know the judge's tone of voice. For that matter, we don't know how the jurors reacted to these instructions. I don't know, this is a little speculative, obviously, I don't know that there were 12 jurors there. I'm not sure that that's entirely crazy, because in this case, the judge only polled 9 jurors when asked to poll the jury, and that's on pages 1866 to 67. I didn't raise that as an issue. I don't think that's reversible error, but the judge only polled 9 jurors. There's a lot of things that happen in court, even if the judge is simply rereading an instruction, that matter, and I think the defendant and defense counsel have a right to be there, and so does the public. In addition, I don't think it's entirely clear that it's entirely accurate to say what the judge was doing was simply rereading an instruction. Obviously, it's basically the same instruction the judge gave when the 404B evidence was admitted. But it's not the same instruction that was in the written jury instructions. The written jury instructions had a limiting instruction that simply said, evidence has been admitted for a limited purpose. You're not to consider the evidence for any other purpose. So if you're comparing what the judge did in giving this supplemental instruction to the written instructions, it is a new instruction. If you're comparing it to what the judge said contemporaneously, it is the same instruction. So I think there's some question there. Maybe it's a little bit in the weeds to debate that. But ultimately, I think the judge should be doing this in open court and shouldn't be excluding the public and shouldn't be excluding certainly the defendant or defense counsel.
By the way, was it the same instruction? Did you go back and look at the transcript where it instructed
It is the
them
same instruction as the
verbatim?
court gave contemporaneously. It is not the same instruction that's in the written
I
instructions.
understand.
The other key aspect about this, I think, is when trivial exceptions occur, as recognized by other courts, often it's inadvertent. The Peterson case, which is the primary case recognizing this exception from the Second Circuit, the judge properly closed the courtroom during the testimony of an undercover officer who was still then undercover. And then that officer's testimony finished, and there was just a mistake. People forgot to unlock the courtroom for approximately, I think, 15 or 20 minutes of the defendant's testimony. Here, this wasn't inadvertent. This was a deliberate decision by the court. And that's, I think, informative of what's going on here and goes to the heart of what the Sixth Amendment right to public trial is about. Again, the idea with the public trial right is that when sunlight is shown on the process, if a judge is going to make a mistake, it's less likely to occur in a public trial forum, and the judge is less likely to be partial in a public trial forum. Again, I'm not saying this judge was biased, haven't raised that issue, but there was certainly tension there. And to serve the purposes of the Sixth Amendment right to public trial, this should all be done open, on the record, with everyone present. I don't have any more points, anything else to say at this point. I'm happy to answer any other questions. Otherwise, I'd reserve my time for rebuttal.
So if we decide the issue in your client's favor, I'm assuming you would concede that we don't need to reach the evidentiary points?
You don't need to reach them in the sense of they wouldn't matter to the result. I think it would be worthwhile of the court to reach, particularly, well, they're all evidentiary. They could all recur on retrial. I think the second issue in the brief would be very important for the court to reach, if only because whether or not it constitutes reversible error, I think it is clear error to say that demeanor testimony somehow is self-serving hearsay. And despite many records, the judge couldn't be persuaded otherwise. And I think given the outcome in this case, which was the jury acquitted of the highest charge and found my client guilty of second-degree murder, but not reckless, and the dispute was all about mental state, I think it would be crucial for this court to give the judge some instruction, some guidance on that, because I don't want to be here again arguing that same issue. So, thank you very much.
Good morning, may it please the court. My name is Brittany Limes, registration number 48733 on behalf of the people. I'll also focus on the public trial right issue, and particularly the triviality issue. Simply put, this closure was trivial. It lasted a matter of minutes during the course of a week-long trial. It occurred after the presentation of evidence and witnesses had already been concluded, and it involved rereading a 404B limiting instruction that had been given twice before in open court and into the defendant's presence. So applying the triviality framework that is used by multiple jurisdictions, the circumstances of this closure made it so innocuous that it just did not violate the defendant's right to a public trial. And so courts, when they're looking at whether a closure is trivial and thus doesn't even implicate the right to a public trial, they're really looking at the four specific goals that the public trial right is meant to promote, and that's ensuring a fair trial, reminding the prosecutor and the judge of their responsibility to the defendant and the importance of their functions, encouraging witnesses to come forward, and discouraging perjury. And when I was looking back at some of the cases that are applying triviality, and finding that certain closures are trivial, there are some facts that can come up again and again. So, such as the duration of the closure. How long did it last? Was it for a significant part of the trial, or was it a brief or fleeting kind of closure? Sorry.
Inadvertent or advertent?
Yes, that is something that courts address. So I think if it's an inadvertent closure, it's much more likely to be found trivial. But for when we take a closer look at some of those cases, the inadvertent versus intentional matters a lot towards the other factors as well, which is, for example, if the court intentionally closes the courtroom like it did in GB, and the witnesses know that the public is excluded, then it really cuts against that public trial right of discouraging perjury or encouraging witnesses to come forward, because the witnesses know that their peers are not going to be there listening to their testimony. And there have been certain cases where an intentional closure was trivial. And that case is specifically is Braun versus Powell. So that's 227 F. 3rd 908. That's from the 7th Circuit. The court there found that the closure where excluding a former veneerman from the entire trial was trivial, even though the court knew that it was excluding this veneerman and mistakenly thought that it would lessen the prejudice to the defendant having him gone. And so I think that while an inadvertent versus an intentional closure is a factor that courts look at, it's not dispositive, and it's not dispositive in this case.
Well, the case you cited, though, that's not a complete closure.
Correct, yes.
Are there any cases involving an intentional as opposed to an inadvertent complete closure that have been resolved on the basis of still trivial?
Not that I've found, Your Honor. So no, I haven't seen a case where an intentional complete closure was found to be trivial. But really the facts of this case are unique, and they're very different than a lot of the cases, really in most public trial right cases that we've seen, and in the triviality realm, mainly because it occurred during deliberations, and it occurred basically rereading an instruction that had been given twice before in open court. And so going back to that intentional versus inadvertent, in this case, the fact, even though it was intentional, it didn't have any impact on encouraging witnesses to come forward or discouraging perjury, because at that point, the evidence was closed. All of the evidence was before the jury. The instruction had nothing to do with the particular facts of the evidence that were presented. And the public got to hear this instruction when it was given twice before in open court. It got to hear all of defense counsel's objections. And so really, this was no different than sending back a written instruction.
Go ahead, Judge.
What about Mr. Mueller's point that there is a transparency issue here that for example, could illuminate the judge's demeanor in reading this instruction?
Your Honor, I agree that closures should be rare for that very purpose of encouraging transparency and reminding the judge and the parties, sort of the seriousness of the case. But I think that, first of all, there's no indication in the record that any frustration that the court was having as they were trying to resolve how to answer this question and how to resolve these objections. There's no indication that was conveyed to the jury. It's hard to tell either way. And for an appellate court, we never really know what the judge's demeanor is unless it's vocalized on the record. But, and I don't think it's necessarily, if the judge was frustrated, all he was doing was reading a transcript of the instructions that he had given before. So I think that, demeanor and transparency are always concerns when we have a closure, but that hasn't necessarily stopped the other jurisdictions who have applied triviality from finding that certain closures that are brief and that don't impact the goals that the public trial right is meant to promote are trivial and just don't implicate the Sixth Amendment.
In the cases where the courts were found to have engaged in a trivial closure, a reason was given for the closure. The apparent only reason given for the closure here was the judge's belief that you don't read a jury, you don't call the jury back in after they've gone to deliberations, which Mr. Mueller said was completely wrong, although he didn't cite a case, he gave examples. Do you agree with that proposition, that it's not so that the jurors can never be called in again?
I think that the jury can be called in certain circumstances. I do think it's important in deliberations that those are supposed to be secret, the jury is supposed to be secluded, and so when the jury does come back out during deliberations, it's for very rare and circumscribed circumstances that we don't have. So for the example that defense counsel gave of a modified Allen instruction, or a DeBella issue where they're coming out to review testimonial evidence. But I agree that I think most of the time when a jury is deliberating, we want to keep them isolated and secluded, and not necessarily be bringing them out all the time in front of the public and the parties again, because that's kind of the time that they're supposed to be deliberating and resolve. So I agree with defense counsel that it's not true that you never ever under any circumstances bring the jury out again, but I think it should be limited and should be rare.
So the judge gave no valid reason here to close the courtroom, did he?
And I think that that's where going back to Braun and Powell, and when I argued Braun versus Powell, and when I argued that a potential remedy that this court could consider is a remand for the court to vocalize any findings, because I think that what happened here is nobody really expected this issue to come up. Nobody thought about Waller. No one thought about the findings, and there may have been circumstances that aren't necessarily in the record that may have justified this. But I know that this court declined to issue a remand in GB. I would leave that to your discretion, but that would potentially be an option if this court thinks that there may have been reasons that just were not vocalized on the record for why this closure, why the public or the parties should be excluded. Significantly, I'd also point this case, the court to Thacker from the Kentucky Supreme Court that I cited in my brief, where the court found that there was no public trial violation when the court excluded the press from the courtroom when the jury came back in to review evidence. And Thacker and Peterson also emphasized the fact that these closures were trivial when they were basically repeating the same substance of what happened in open court in a closure. So, in Thacker, they were being presented with evidence that had already been presented in open court. In Peterson, the court found that the closure was trivial because right after they opened up the courtroom, defense counsel's summation really reiterated all of the defendant's testimony from when he was testifying, so the public was there to hear that. And in this situation too, this instruction was given twice before in open court. The public got to hear it, the defendant got to be there for it. Defense counsel was able to raise objections to it. And in the course of this week-long trial that was very emotional, this a couple-minute-long closure, which really goes one transcript page out of about 1,200, sorry, was just it was trivial and did not violate his right to a public trial. And so to briefly address, I think, Judge Fox and Judge Webb's questions about, what issues to address if this court disagrees with me and finds that this did violate the right to public trial. I do think this court should address the evidentiary issues just because, as a matter of judicial efficiency, these were heavily litigated below, and I think it would give the court and the parties some clarity and some assistance in those. I don't think the court needs to reach the right to be present issue if it reverses on the public trial right issue, because that is not a situation that's probably going to arise again on retrial.
So then address the demeanor testimony that Mr. Mueller referred to. The defendant was precluded, I think, from calling or asking a witness, police officer witness, about his demeanor before the police officer?
So I think in the context of this, defense counsel was precluded from asking Sergeant Bundy about a different detective's observations of the defendant's demeanor, which I think, setting aside for the moment whether or not the demeanor is self-serving hearsay, I think that's a proper ruling for the court. Sergeant Bundy didn't have any personal knowledge about wasn't there when the defendant was being interviewed by Detective Fatz, so that wouldn't have been a proper cross-examination for that. And for when she ultimately testified, the prosecutor didn't elicit any testimony on direct about her observations of the defendant's statements or the defendant's demeanor. The only thing they asked was if she observed anything on his forearms that day, which is clearly different from demeanor testimony. And significantly, the court's ruling didn't completely deny defendant the right to put this evidence before the jury, because the court said if the defendant wants to testify about how he was feeling or what he said to the detectives, he could take the stand and testify, and had the opportunity to do that. And so the fact that the defendant here made a strategic decision to avoid being cross-examined and to avoid testifying doesn't necessarily completely deny him of his right to present a defense. And I'd also like to point out that any error here was harmless. A person's emotional state a day after, a homicide, it was really marginally relevant to the issue of what his mental state was when he committed the murder. I think that a person can feel bad about killing someone a day later, whether they did it intentionally or whether they did it recklessly. And I think that on cross-examination, defense counsel was able to temper this evidence from Detective Bundy about, I never saw him be upset about her death in any of my interactions with him. Defense counsel was able to come back and say, well, isn't it the case that people react differently to the death of a loved one? Sometimes you're crying, sometimes you're numb or withdrawn. And so in the context of the entire case, the exclusion of this evidence was harmless and doesn't warrant reversal, even if this court concludes that this demeanor testimony was not hearsay or was not covered by the self-serving hearsay instruction. If this court doesn't have any further questions, the people would respectfully ask to affirm the defendant's conviction. Thank you.
Thank you. I just have a couple of points I'd like to make. The Attorney General noted that there's no indication on this record of the judge's demeanor during the rereading of the instruction, and I would submit that's precisely the point. We don't know what the judge's demeanor was because the courtroom was closed and the defendant and defense counsel weren't there. So if defense counsel and the defendant had been there, a record could have been made if the judge's demeanor was perhaps improper. And that's why the error here and the prejudice from the error is unquantifiable. And that's why the right to public trial is structural error, because a reviewing court isn't in a position to say, how did this impact the jury's verdict in the case? That's just something that's metaphysical. That's something an appeals court can't do. And that's why the Supreme Court has said it's a structural error that requires reversal. The second point I'd like to make is really about triviality. And the Attorney General argues that rereading an instruction is basically a trivial matter if it's just repeating something the jury has already heard. I'd submit in many cases there's really no endpoint to that logic. When the judge impanels a jury in Colorado, it gives preliminary instructions, one of which is the reasonable doubt instruction. Now, if the judge excluded the juror, excluded the public and the defendant and defense counsel later on, when the court was giving its instructions and reread the reasonable doubt instruction, which it gave on the first day of trial, I would submit this court would easily conclude that's a public trial violation. And I just don't think there's a principled end to the logic the Attorney General advocates here. And so I don't think the court has to go there. The court can just say on this record, it wasn't a trivial violation, and the court doesn't need to decide or draw the line about what type of instruction might be trivial when reread and what type of instruction might not. What about the credibility of witnesses? What about the instruction that says jurors can view direct evidence just as they would circumstantial evidence? Where do you draw that line? I submit the court doesn't have to engage in that analysis. I see I'm almost out of time, so if the court doesn't have any other questions, I'd rest on my arguments in the brief and ask that this court reverse. Thank you very much.
We appreciate the arguments of both counsel. The case stands submitted. We will issue a written opinion in due course. Counsel in Lujan are excused. We're not going to take a recess when the tables are cleared. Counsel in Lindsey may set up, and I'm going to give counsel in that case some preliminary thoughts before the clock starts running. All right, our preliminary thoughts are as follows, and I encourage my colleagues to speak for themselves if I mischaracterize anything. But let's assume, and we have not certainly prejudged this issue, that we conclude the lower court did not comply with the competency statute. The question that we have been pondering, which really isn't addressed in the briefs deeply, if at all, is what next? I mean, for example, and you may perceive other alternatives, but we'd like to be informed of your positions. Does that mean that on remand, the lower court should conduct a retrospective competency evaluation as of the date the motion was filed, which is on the eve of trial? If not, does that mean that the lower court should presume the defendant incompetent and require the prosecution to establish competency before a new trial can occur? Does that mean that the defendant would not be presumed incompetent since he was never found to be incompetent, but trial counsel before the retrial can renew a motion suggesting incompetency? So those are some things that we have considered, we have thought about, which the briefs don't develop. But as always, you have 15 minutes per side, and you're welcome to use your time however you wish.
Thank you, Your Honor. May it please the court, Counsel Robert Fishman on behalf of the appellant William Lindsey. Two cases that I will cite that I think address all of Your Honor's questions. The first is People versus Presson. That is 315 P. 3rd, 198. It's a 2013 case from this court. And People versus Mondragon, which is 217 P. 3rd, 936, a 2009 case from this court. What you have in Presson is a district court that did not follow the dictates of the competency examination, competency statute. This court deemed that to be an error, and the question was, what do we do now? And the court in Presson noted two things that I think hold absolutely true in this case. The first was the motion was raised in a timely fashion, meaning prior to trial, which is true of our case. And the court went on to say, we're issuing our decision 3.5 years after the trial of this case. And under those circumstances, we think it would be flatly inappropriate to order a retrospective competency exam. So the remedy in that case, which is the remedy we would urge here, is a reversal of all counts of conviction, and you start over again. I can't tell you, frankly, what a new trial lawyer might decide about this question if a trial were to occur tomorrow. Maybe that lawyer would say, I don't think we have a competency problem. Now, I think we're ready to proceed and go to trial, in which case there are none of these kind of thorny questions. Or the lawyer could say, I'm filing a motion to determine competency, in which case the statute kicks in and you follow the procedures. And if the court says, I don't have enough information, the court can order an exam. If the court says, I've read the motion and I've observed the defendant, I think that he is competent, and either party objects, you have an evaluation. And it's dealt with the way it's dealt with in any other case. Now,
But you're not suggesting that on remand, the defendant is presumed incompetent, and therefore the burden has already shifted to the prosecutor to establish competency?
I don't think, no, I don't have any statutory or legal basis to make that claim under the current law.
Thank you.
The old law had presumptions that could work. I don't think the new law works that way. I think you start fresh, and you start fresh.
All right, follow-up question then on the retrospective competency issue. I respect that the Preston Division determined that at the appellate level, although it cited contrary authority. Why is that a proper determination to be for an appellate court to make, as opposed to remanding and letting the trial court in the first instance decide whether it had or could obtain sufficient information to commission a retrospective competency evaluation, which would seem to me to be a very fact-driven determination that appellate courts, make only in compelling circumstances.
Right, and I think that probably the best answer to that question is to discuss the Mondragon case, the other case I pointed out from the start. That's a case where a court applied the incorrect legal standard in determining competency, didn't make a ruling, didn't order a second competency exam, that was the problem in that case, proceeded to trial, and the court there said, well, this is structural error and we're gonna reverse, number one, but then kind of curiously after saying that, said we're going to remand the case for the court to decide now whether an exam is called for under the old statute. But the reason the court in Mondragon did that is because the court specifically said there were several expert reports evaluating the defendant's competency in this case. There is sort of a complete evidentiary record that was created contemporaneously with the trial. It is before the district court, and in light of those circumstances, we think it's appropriate for the court to take a look at this. Now, that contrasts here. All that you have is a 4.5-page motion from counsel. That's all. The court circumvented the statutory procedures and precluded creating a meaningful record 3.5 years ago by doing that.
Well, let me take issue with that. The defendant testified at length, correct, in the trial?
Correct.
So that would be some indicia, one way or the other, but that would certainly be some indicia of competency. He went immediately to DOC, and for all we know, he may have received extensive psychiatric treatment in DOC. So I guess my point is we just don't know. Well,
we don't, I think that's right. We don't know. I mean, I would say that in terms of my client's performance at trial, what makes me squeamish about that is it hints at prejudice, that there's prejudice in forcing a potentially incompetent individual to face trial, and that's not what I think we should be talking about. I think it is structural error, number one. Number two, I think that ends up getting very, very thorny, the sort of job that my client did on the stand, because you can't assess that in a vacuum, and you have to look at the job his lawyer did at trial. And there's just the one evidentiary question, right, asking the Liggett issue as in terms of my client's testimony. So I don't know how carefully the court may have reviewed the 2 days of testimony by my client at trial. The issues on appeal didn't really call for it. But I can tell you, it's a pretty remarkable 2 days of testimony.
Well, I'm not suggesting that we would be competent to make an independent judgment, but
Yeah.
it seems to me a psychiatrist could read that and say, there are indicia here of competency, or there are indicia of incompetency.
You know, that, I think, again, the problem is, the statute calls for this all to occur contemporaneously and prior to trial. And so even if Your Honor is right about that, and some expert might have come back and said he looks competent, that's not conclusive. I mean, you can request a hearing, you can demand a second competency exam, a court has to make a ruling, and I think Presson is on point when it says 3.5 years down the road is just too late. And
And refresh me, how far down the road are we in this case from the
3
trial?
years, 2 months.
Okay.
So that's the answer. I really think the problems and all the potential downsides, I mean, I think we can agree. I am not a psychiatrist, but I'm sure we can all agree that a contemporaneous evaluation is preferable to one that is based on a record where you can't tell demeanor, you don't get a lot of information from a record oftentimes. It's not the best evidence of competency. And in this case, it really is the fault of the district court that we're in this predicament, and we're talking about second and third best options on how to deal with this. The prosecutor at trial was correct. Defense counsel made the motion, and counsel got up and said, well, Your Honor, here we are under the statute. You need to make a preliminary determination. And if he objects, we stay, and we get an exam, and we follow the law. And so I think that's what should happen in this case on remand. You should follow the law.
Let me clarify, though. Is the error you're asserting that the lower court made a competency determination and then didn't allow counsel an opportunity to take issue with it? Or is your issue that the trial court erred by effectively dismissing the motion as facially inadequate and therefore never ruled on made the preliminary ruling on defendant's competency? I think it has to be one or the other.
Well, given the ruling, I think that it doesn't have to be one or the other, but as a practical matter, it is one or the other. I mean, my position is the court made an initial ruling that he's competent to stand trial, but in the next breath says, by the way, this is not even a competency motion. I mean, I think he realizes to take, not, I think, an unduly uncharitable view of what happened. He makes the ruling, and I think as he's doing it, he realizes, I know what this means. I mean, I'm making a ruling, and if this guy objects, we stay the trial, and off to the state hospital he goes. So in the next breath, he says, you know what, this is not even a competency motion at all. He didn't know whether to deny it, he didn't know whether to strike it, but what was clear is the court said, I'm not making a ruling that you can object to and trigger a right, statutory right for an exam. So he made the preliminary finding. I think it falls by the wayside in the ultimate ruling where he says, we're not even talking about competency here. If there's no other questions.
I have a question.
Okay.
Let me take you back to the retrospective psychiatric evaluation. You cited 2 cases that discourage it. But there's a third case called Carici. And in Carici, our court said, although retrospective competency hearings are disfavored, they are permissible, and it listed 4 factors the court should consider. Can we apply that case here? The factors being the passage of time, the availability of records, defendant's statements at trial, availability of individuals and witnesses who interacted with defendant before and during trial. And I'll remind you that the probation officer was going to be offered up by the prosecution
Yeah.
to give her view.
Well, I would say a couple things about that. Number one, you're quite right, Judge Webb, in your initial comments that this was not developed in the briefs. We asked for a new trial. That was the remedy we asked for in our opening brief. And the prosecution said nothing about it. Now, typically, you fight over standards of review. You fight over the burden of whether you have to show prejudice or not. You fight over inappropriate remand. There was no fight in this case, which is why now I'm citing cases to you that were not cited before, and you are citing cases to me that have not been cited before. So I think the first point is, I'd argue it's a waiver. We asked for relief, it was not challenged. The second point, I have not studied Caruso, so I'm at a bit of a handicap. I would say the first factor, passage of time. This is almost 3.5 years. I don't know the time involved there, but maybe it was more, maybe it was less. 3.5 years is a long time, so I'd point to Preston again. I'm sorry, 3 years, 2 months. It is disfavored. I think that's right. The presumption is you don't do it. You can call the probation officer. I'm pretty sure we have a good idea what she is going to say. You have the trial testimony. Again, for the reasons explained, I think that's just treading on dangerous ground. And ultimately,
You have the trial judge's observations, for whatever they're worth.
yes,
you do
but
have
the
the
trial
trial.
judge's observations, he didn't make any observations about the defendant's competency. He says he understands what's going on. I've seen him in the proceedings. He's been charged with crimes before. He's been involved in litigation. He understands that we're in a court of law, that I'm a judge, that that's his lawyer, that's the prosecutor. That's not what the competency motion was about. So it's disfavored. I think it's disfavored for a reason, and I think under the facts of this case, not only the passage of time, but the paucity of information. There is no contemporaneous expert report. And the fact, again, that this is all the product of the district court's error. It's not our fault, and really, it's not the prosecution's fault. And under those circumstances, I think you follow the presumption. It's disfavored. So you go back and you follow the law the way it should have been followed 3.5 years ago. And with that, I'll reserve a minute and 15 if I may.
Good morning. May it please the court. Kevin McReynolds, Colorado Bar number 40978 on behalf of the people. Before turning to this court's question regarding remedy, I'm going to start with a rather radical proposition, which is that the court did not err by following an unbroken line of 30 years of case law and a statute that did not change. So defendant's claiming an absolute right to a competency examination whenever his counsel raises one. Yet in the opening brief, he had conceded this was an issue of abuse of discretion that was within the court's discretion. That part was correct. The people agreed that this was an abuse of discretion standard, and his claimed right to a competency evaluation, absolute, whenever his counsel raises it, under the amended statute, is wrong for 3 reasons.
Excuse me, but
Yes.
before you get to the 3
Yes.
reasons, what are you saying is the discretionary ruling below? Is the discretionary ruling, which I tried to characterize with your opponent, that the motion is facially insufficient, or is the discretionary ruling the court's preliminary determination that the defendant appears to be competent?
It's whether or not it has raised the issue properly.
So that's
As
the facially inadequate.
That's the facially inadequate. That is how the ultimate ruling was. That's what Marino speaks to, the 1987 case that the people cited. And that's what In Re WP, which defendant relies on, also recognizes as, at page 159, if a court has reason to believe the defendant in a criminal trial is incompetent to proceed, the judge is then duty-bound to suspend the proceedings and determine competency or incompetency under the statute. That's the threshold determination. That has not changed. This is the key point to understanding why the trial court's ruling is not incorrect, why we're getting ahead of ourselves to say, well, let's just presume the court erred, and then we need to start thinking about what the competency examination is. The statute, both before and after the 2008 amendment, specifically provides the exact same quoted language. It was under former section 16.8.110. If the judge has reason to believe the defendant is incompetent to proceed, it is his duty to suspend the proceeding and determine the competency or incompetency of the defendant. Now that's in subsection 2A. When they repealed and reenacted the competency statute and created new rules regarding once that trigger has been met, how we proceed from there. They did not change this language. The legislature put it in 16.8.5102, again at 2A, exact same language. Now, we have a canon of construction in this jurisdiction that our Supreme Court has long adhered to. When the legislature reenacts or amends a statute, does not change a section previously interpreted by settled judicial construction, it is presumed that it agrees with that judicial construction of the statute. This ends the legal issue here because the legislature, the General Assembly, by repealing and reenacting and using that exact same language that Moreno and Wingfield and Kilgore and Siegler, which the trial court cited, all applied to recognize that courts have discretion to see whether or not competency has been properly raised.
Counsel, how do you explain away then the fact that the prosecution understood what he was raising and the prosecution agreed that the court needed to proceed to the next step, to the first determine competency and then find out if there was an objection?
Well, I would point to the transcript there. The prosecution mentioned that, and the trial court responded by saying, I'm going to get to that in a minute, because the trial court had reviewed this case law, had reviewed this statute, which had been construed since 1987, and specifically, in making its ruling, cited to Siegler, which is at 832 P3rd 980, which specifically quotes Moreno and quotes this very sort of this issue. It requires a suspension of the proceedings for a hearing incompetency only in those instances in which the judge has reason to believe the defendant is incompetent.
But what about the next paragraph? The next paragraph, 2B says if the defense has reason to believe the defendant is incompetent, it shall make a motion, which is what happened here.
This is the way that it has been interpreted. I understand what defendant's argument is that Moreno is wrong and that this is just about how the issue is raised. This court, divisions of this court and the General Assembly, by adopting that construction, have read the reason to believe language as providing specifically the courts with substantial discretion to determine whether or not competency has been properly raised.
So you're saying even if the defense has reason to believe, we still have to go the next step and decide whether the judge has reason to believe, and if the judge never has reason to believe, that's the end of the story?
I think that if the judge did not abuse their discretion in making that determination, yes, that is the end of the story. And that is precisely the issue Moreno addressed. And what it said specifically is there's an initial presumption of competency. No defendant is entitled as a right to a competency examination or hearing by just making a demand.
Counsel, but often, obviously, defense counsel has much greater opportunity to interact with the defendant, to observe the defendant, to, get a sense of his or her competency. The trial court may never hear what a defendant says. It could be a situation where the only person the court has heard from is defense counsel.
I think that is a theoretical possibility, and that is how we would be reviewing something as to whether or not the trial court abused its discretion making that threshold determination. That being said, those are the types of factors that Moreno says the courts are supposed to look to. They have an opportunity to observe defendant. They can look at their actions and general demeanor. They have substantial discretion in determining whether the issue respecting competency has been raised. And on the record here, defendant's entire motion, which was 48 hours before the 8th trial setting when he'd spent the last month fighting to not have to represent Mr. Lindsey at trial without getting paid for it, were all about the fact that he wasn't interacting with Mr. Lindsey. And that is why the prosecution...
And isn't that some indicia of perhaps his, Mr. Lindsey's sanity?
Well, I would point out that having good judgment or making good life decisions is not what the competency examination or the competency statute is about. It's about whether or not they have a rational ability to understand what's going on, whether they have a rational ability to assist in their defense. Not that they do so, not that they're making the best life choices. Competency is a very low standard because we're really trying to keep from trying people who have no idea what's going on. And that is why all those observations the trial court made in finding the history of this case shows me that this is not made in good faith. The history of my interactions with him and his filings with the court, his letters that he filed with the court, shows that he knows exactly what's going on. And so if you'll allow me, I'll point, the record supports that there was no abuse of discretion. We agree with defendant's opening brief position that this was an abuse of discretion question. We think that by reenacting the statute word for word the way it has been applied by divisions of this court as recently as Nagy and Wingfield, that nothing about the statute changed. The legislature has not taken away courts' initial discretion or the presumption of competency that has to be overcome to trigger the competency examination and the competency statute, which we agree. Once triggered, it is now mandatory that there be an evaluation. And that is something that did change. That is what WP was discussing, the sections that did change there. Assuming you disagree with me and you think that the reason to believe language, either Moreno's wrong or the legislature didn't adopt that construction by reenacting the exact same language, though they changed other things to take away judicial discretion. Turning to your question of remedy, I would submit Preston, Mondragon, I don't remember if it was Karachi Judge Richmond came up with, those were not in the briefs. The people did not address them. If the court would allow me an opportunity to respond by supplemental motion, I'd be happy to do that very, very briefly, since I am at a loss to respond to authorities defendant did not cite. That being said, I have read previously the concept of there being the ability to do a retrospective competency evaluation. I think we have more record here than we usually do because we do have the testimony. We do have his court filings. We do have a probation officer who was willing to testify. We do have a court who not only had dealt with him before in all the pretrial proceedings for years that it dragged on, but also dealt with him during a 9-day trial and addressed him directly during that 9-day trial and has even had greater ability to make observations about his demeanor during that 9-day trial.
Would you
Yes.
concede that on our record that retrospective examination could not be done? Because, for example, even though the prosecution proffered the probation officer to speak to her observations, we don't have an affidavit or a testimony or, that
I
information.
completely agree with that. That is precisely why this court should not make that decision. If this court finds that Moreno was somehow overruled and is no longer good law after the 2008 amendments, while we disagree with that point, we think that then the correct remedy would be to remand for a retrospective competency examination. Yes, a lot of time has passed, but we have record from the time that can be used and can be reviewed by somebody making a competency evaluation, whether that be the trial court to make its initial competency finding and then have an objection, which under the new statute does trigger a right to a competency evaluation that is done. That would be, I think, an appropriate remedy here if we do get to that point.
Why, now this is the same question I think I asked your opponent. Why should we decide whether a retrospective evaluation is feasible, as opposed to if we conclude that the lower court erred in dealing with the motion, let the lower court decide feasibility?
I think that is also an appropriate thing. I think you could remand with directions that, if feasible, to conduct a retrospective competency evaluation. I think that is a call that the trial court would be better suited to make, precisely because they sat through the 9-day trial with Mr. Lindsey.
And I do not intend to spurn your suggestion for a supplemental brief. We will discuss that after orals, and if we want the parties to submit supplemental briefs on that, you'll get a written order very quickly.
Understood, Your Honor. Judge Richmond.
I'm a little confused because I think at one point, counsel for the defendant said, well, we don't even know if we're going to make a motion for competency if this case is reversed and remanded. So it seems like we have an obligation to at least give the court some directions, not just to reverse the case, but direct the court to specifically decide whether a retrospective competency evaluation. I don't want to reverse the case and go back to square one and this all goes away. That doesn't make any sense to me.
Well, and I think that's a problem that's created by defendant's proposed remedy here, which is I just get to go back and then say that there's no competency issue at all, having gotten a reversal, having overturned the jury's verdicts after a 9-day trial, and gone through all that expense, especially because, again, the people don't think the trial court abused its discretion in finding there was no basis for a competency examination or a competency evaluation in the first place. But I agree with you, Judge Richmond. I think that if this court finds that the trial court was required to make a competency finding, it should direct the trial court to, if feasible, conduct a retrospective competency evaluation, and based on the outcome of that determination, either proceed to a new trial or reaffirm the judgment.
Take the decision out of the hands of the defendant.
Yes. I think that that is what's necessary in order for, he's asking for relief based on a particular issue. If he gets the relief without proving that issue occurred, we're really reversing for no error. Does the court have any questions regarding any of the other issues? We would ask this court to reaffirm Moreno and the 30 years of case law saying that the reason to believe standard provides courts with discretion as to whether or not the competency evaluation has been triggered, and that mere representations by counsel alone are insufficient. Thank you.
3 points. I think the court is aware it's fairly self-evident. You have competency evaluations that are ordered by a court when a court has reason to believe a defendant is incompetent, and you have motions to determine competency by parties that do not implicate a judge's reason to believe and the 30 years of case law that was decided under a statute that in re WP says have been superseded by the 2008 amendments, number one. Number two, this is not a futile exercise. I'm an appellate lawyer. I have never met my client face to face. I cannot tell you whether he's competent today, and if I could, it would tell you nothing about whether he was competent 3.5 years ago. So this idea that, oh, maybe they don't raise competency again 4 years later, well, gee, isn't that crazy that he gets a new trial? No. You need to know his mental condition 3.5 years ago. The final point I would make, kind of the final run, I'd go at your point, Judge Webb. We have at least 3 cases, 2 of ours, 1 from Judge Richmond, where this court decides what to do, okay? You have an error of law, you have a court failing to follow the law, you have a record. That's what this court does. It reverses and it says what should happen, and I think you're in a position to do that, and I am out of time.
We appreciate the arguments of both counsel. The case stands submitted. We will issue a written opinion in due course. Counsel in this case are excused. We have no more cases for the morning, and the bailiff may announce a recess.